So you signed a CNR, the judge approved it, and now you've changed your mind. Can you get out of it? Can you get that CNR canceled? Can you get the compromise and release set aside? It is an uphill battle. It is not an easy thing to do. The general rule is a compromise and release is treated like a contract. So once you sign the compromise and release, once the defense attorney or the claims adjuster signs it and the judge approves it, that's a finalized contract. And a lot of contract law applies to trying to get that set aside. So is it impossible? No, it's not impossible. It's just really tough. So let's go through some of those options. First of all, you're generally going to have to file that petition to set aside. That's what you would go about doing it. Petition to set aside, you have to show good cause. We'll get to that in just a moment. You're also generally going to have to file it ideally within 25 days of the order approving issuing. That would be the same timeline for a petition for reconsideration. But again, it absolutely must be done within 5 years of the date of injury. Generally, the board loses jurisdiction over cases once they get to the 5-year mark and the case has been settled. So let's say you settled your case, you signed the CNR, the judge approved it, they sent to you the check, and now you want to file a petition to set aside. You want the judge to invalidate that compromise and release. You want to start all over again. You're going to have to show good cause to get that settlement set aside. What is good cause? You change your mind and you think, you know what? I want the insurance company to pay for my medical treatment after all. Not good cause. The judge will not set it aside for that reason. You think further about it and you say, you know what? I think I made a mistake. I probably should have demanded more money. Not good cause. You've entered into a contract. It's been approved, finalized. Good cause does not exist where the injured worker changes his or her mind. What if you didn't really complete enough discovery? You had gone to your treating doctor a few times, you had an accepted knee injury, and your doctor said you really should get your back checked out. I'd recommend an MRI study to find out if anything is wrong with your back. But you decide to go ahead and settle. It settles all issues. Everything's taken care of. A couple of months after the compromise and release is approved, you think, my back is still bugging me. You get an MRI. You find out you've got more extensive damage than you thought you had. Is that good cause? Generally not. You should have completed discovery before you entered into the settlement, and the judge approved it. So you're saying, Lusk, what is good cause? At least give me a couple of examples. Again, it's tough. You're going to have to show fraud, some sort of concealment, a detrimental reliance by the other side. It's very difficult to show fraud. You could show mutual mistake. Both sides entered into the agreement believing a certain item to be one way and it was another. Both parties entered into the agreement. They both listed some body part and it was a completely different body part, God knows. But both parties made the exact same mistake. Nobody noticed. That might be good cause to get it set aside. But of course, that's not the injured worker changing his or her mind. This is both sides making a mistake. So mutual mistake, fraud. If you show duress, again, this is tough. Cases have been argued where the injured worker has an attorney and the attorney says, I really think you should take this settlement. If it goes to trial, you might lose and get nothing. Or you should take this settlement. Another offer might be lower. This is better than what you're going to get. Time goes by. The injured worker changes his or her mind and says, hey, my attorney put a lot of pressure on me. My attorney told me I should take this because I wasn't going to do any better. That is not duress. It has to actually be duress. Again, very difficult to show. If you have videotape, let's say, of the claims adjuster holding a gun to your head, you've got duress, but it's, again, tough to show. What else could be good cause? Incompetence could be good cause. If you enter into a compromise and release, you don't know what you're doing. Time goes by and a doctor finds that you were incompetent at the time of the signing of the compromise and release. That could be good cause. You didn't have the mental faculties to enter into that agreement and understand what you were doing. Of course, if this occurs, chances are you're not going to be filing your own petition to set aside, because you would have to argue that you were competent to file the petition to set aside but weren't at the time the settlement was approved. That's, again, an uphill battle. So really, the bottom line, if you've signed a compromise and release, the judge has approved it, and you want to get out of it, you can file a petition to set aside. It's going to be an uphill battle. You're going to have to file the petition with the board, serve all other parties, the adjuster, defense attorney if there was one, and you're going to have to show good cause to a judge as to why that should be set aside. I'll say good luck to you. It's a difficult thing to prove, but not impossible. If you found this video helpful, hit the like button down below and make sure to subscribe to the channel so you don't miss any new videos.